Functions and jurisdiction of the Supreme Court. The Supreme Court is the highest court of appeal. The jurisdiction of the Supreme Court is wide, and the judgment given by the court is binding on all the courts of India. The jurisdiction and powers of the Supreme Court are as follows. First, original jurisdiction. Disputes like A. Between the Government of India and one of the states. B. Between the Government of India and any state or states on one side and one or more than one state on the other. C. Between two or more states. D. Regarding election of president and vice president. All such disputes fall under the original jurisdiction of the Supreme Court. What does it mean? It means that all these disputes are directly brought to the Supreme Court without going to the lower courts. But this original jurisdiction of the Supreme Court does not extend to the following disputes. A dispute arising out of any pre-constitution treaty, agreement, engagement, or other similar instrument. B. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. C. Interstate water disputes. D. Matters referred to the Finance Commission. E. Adjustment of certain expenses and pensions between the centre and the states. F. Ordinary dispute of commercial nature between the centre and the states. G. Recovery of damages by a state against the centre. Second, writ jurisdiction. The Supreme Court has original jurisdiction with respect to the writ jurisdiction. It means that an aggrieved person can directly go to the Supreme Court without going through the appeal process. The Supreme Court has the authority to issue writs like habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of fundamental rights of an aggrieved citizen. There is a difference between the writ jurisdiction of the Supreme Court and the High Court. Let us see what it is. The Supreme Court's writ jurisdiction is not exclusive because High Courts also have the authority to issue writs. The Supreme Court issues writs for the enforcement of fundamental rights and not for any other reason. But the High Courts issue writs not only for the enforcement of fundamental rights but also for a variety of other reasons. Thus, the High Court's writ jurisdiction is much broader or wider than the Supreme Court's writ jurisdiction. Appellate Jurisdiction. Supreme Court is the highest court of appeal. This means that a person can appeal in the Supreme Court against the decision of the lower court. Appellate jurisdiction has been classified under 4 heads. First, appeals in constitutional matters. A. In constitutional cases, an appeal to the Supreme Court can be made against a High Court's decision if the High Court certifies that it involves a substantial question of law that requires interpretation of the Constitution. B. The party in the case based on the certificate can appeal to the Supreme Court claiming that the question has been incorrectly decided. Second, appeals in civil matters. In civil case, any judgment of a high court may be appealed to the Supreme Court if the High Court certifies A. That the case involves a substantial question of law of general importance. B. That the question needs to be decided by the Supreme Court. Third, appeals in criminal matters. In criminal case, the Supreme Court hears appeals from a higher court's judgment if the High Court A. has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or B. has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death, or C. certifies that the case is fit for appeal. Fourth, appeals by special leave. A. The Supreme Court has the authority to grant special leave to appeal from any judgment given by any court or tribunal in the country, excluding military tribunal and court-martial. B. This provision contains 4 aspects. 1. It is a discretionary power and hence it is not a matter of right. Second, it may be related to constitutional, civil, criminal, income tax, revenue matters. 3. It can be awarded in any final or interlocutory judgment. 4. It can be granted against any court or tribunal and not necessarily against a high court, except a military court. The special leave petition tend to choke the Supreme Court, but many times they are rejected at the admission stage, so it keeps the balance. Fourth, advisory jurisdiction. The President may seek the opinion of the Supreme Court on 2 types of issues. A. On any question of law or fact of public importance that have arisen or is likely to arise. B. On any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, or other similar instruments. In the first case, the Supreme Court may give or may refuse to submit its opinion to the President. But in the second case, the Supreme Court must give its opinion to the President. The opinion is only advisory. It is not binding on the precedent. For example, Kerala Education Bill versus Unknown 1958, Kaveri Water Disputes Tribunal in 1992, 2G Spectrum case verdict, and the mandatory auctioning of natural resources across all sectors in 2012. Fifth, Court of Record. The Supreme Court has two powers. A. The judgments, proceedings and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted and cannot be questioned when produced before any court. They are legal precedents and legal references which can be used in similar cases in the future. B. It has power to punish for contempt of court either with simple imprisonment for a term up to 6 months or with fine up to rupees 2000 or with both. The Supreme Court has power to punish for contempt not only of itself but also of high courts, subordinate courts and tribunals within the territory. Contempt of court may be civil or criminal. Fair reporting of judicial proceedings and reasonable criticism of judicial acts do not amount to contempt of court. Sixth, judicial review. It is the power of the judiciary to declare legislative enactments and executive orders of both the central and state governments as unconstitutional if it goes against the basic principles of the Constitution. The enactments and orders which are invalid or null and void or ultra vires cannot be enforced by the government. Seventh, other powers. A. The Supreme Court is the final arbiter of constitutional interpretation. B. The Supreme Court has the authority to examine its own earlier decision in the welfare of society and for securing justice. For example, the Supreme Court deviated from its previous decision in the Keshava Ananda Bharati case 1973. Thus, it is a self-correcting institution. C. The Supreme Court has the authority to withdraw matters from the high courts and decide them on its own. For example, Umesh Chandra Shukla versus Union of India. It can also transfer a case or appeal that is pending in one high court to another. For example, in 2018, the trial of the gang rape and murder of the minor girl in Kathua was transferred out of Jammu and Kashmir to Pathankot District and Session Judge. The court can also refuse transfer of case from one court to another court. For example, Ram Chandar Singh Sagar versus State of Tamil Nadu. D. The Supreme Court has the power to supervise the working of all courts and tribunals within the territory of India. It is confined not only to administrative matters but also judicial matters. This is to keep subordinate courts within their prescribed sphere and prevent usurpation. Thus, the Supreme Court is the highest judicial authority, and its authority is binding on all other courts within the territory of the country. It is the guardian of individuals' rights and liberties, custodian of the Constitution, and ensures social and economic justice to all.